Delivery order last year. The item number 11 of the month. How? Yes.
With the consent of the other side, I'd like to mention item number 11, Your Lordship. The matter may kindly be passed over for the day.
Why?
Your Lordship, my senior is out of station.
Out of station. Why application was not moved yesterday? A prayer is made on behalf of Miss Admel Gop, learned counsel appearing for the petitioner for an adjournment in the matter on account of personal inconvenience. Prayer is not objected to by the learned counsel for the respondents. Post op. Registry to list this matters again after 2 weeks on a date to be fixed by it. Registry to list this matter again on a date video, 15/5/2025. Yes.
Person, I like to mention item 16 with the consent of the other parties.
What happened to the exercise? You're not a, they say you're not a regular forest dweller.
No, it's regarding my termination of the last agreement.
Which one?
16. No. Lulu service.
Item number 16 is Murmu.
Yes, sir.
Your item is 17. Yes. Why you want an adjournment?
With engaged country due to some personal difficulties with engaged country.
Miss A. Zahan or SI?
SI.
Same. SI Khan Kuritiwa. After data. Okay. 25.
May I please, Your Lordship, with the consent of other side, I'd like to mention item number 20. It may be listed after 2 weeks.
Huh?
It may be listed after 2 weeks.
Why?
The petitioner could not come due to Panchayat election.
The
reply is ready.
reply is to be filed long back, but you have not filed.
It is ready, Your Lordship. We will file it in today.
What do you say?
But I say.
You should have you informed him yesterday.
Yes, this morning informed. One thing maybe, might not, there can be fixed on 26th of this month.
26. Okay. As agreed to by the learned counsel, post op. As agreed to by the learned counsel for the parties, registry to list this matter again on 26/5/2024. Full stop. The petitioner is at liberty to bring on record his rejoinder in the meanwhile. Rejoinder to the affidavit filed by the respond number 3, 4, and 5 in the meanwhile. Government is not filing any affidavit. Parties are at liberty to complete their pleadings in the meantime.
Item number 22. On payment of form.
Have you seen the affidavit of the superintendent of police? What is left after that?
You have to file the reply.
Huh?
File reply.
You have not filed reply. Well, then you make a prayer for that. Mr. Z. Hussain, learned counsel for the petitioner, submits that he be granted. Filed. That's not on record. Why you want an adjournment in the matter? Why? Mr. Z. Hussain, learned counsel for the petitioner, prays that he be given 2 weeks' time for arguing the matter on account prays for an accommodation today on account of prays for an accommodation today on account of personal inconvenience. Prayer is not objected to by the learned counsel for the respondents. Registry to list these matters after 4 weeks on a date to be fixed by. Mr. Deka, you're waiting for that judgment. Need not wait. We'll pass it. There are 5. How much I can do it, I'll do it today only. Okay. Mr. Kolta, your thing have dictated, so that is disposed of. Dismissed. And Mr. Bhattakur is here. Mr. Bhattakur, I have also passed your orders.
Item number 2 and 4.
2 and 4, if possible, we'll do it today. Mr. Talda, I have disposed of your matter. You will have the orders on 8th because some corrections are there. They'll do it on 8th. You will get it. 8th. I'm sorry, I have dismissed your writ petition. I have dismissed the writ petition. 8th, you will get it. 3 and 4 disposed of. Okay?
The Lordship. Lordship, item number 13.
Huh?
Item number 13,
30,
1-3, Lordship.
1, 3.
Lordship, as per instructions, I'd like to withdraw this matter as an authorized Lordship.
Ms. N. Begum, learned counsel for the petitioner on instruction submits that she be permitted to withdraw the present writ petition. Prayer is not objected to by Mr. N. Goswami, learned. Not objected to by the learned N. Goswami, learned counsel for the respondents. Full stop. In view of the above, the writ petition stands dismissed on withdrawal.
However, I'd like to pray for a liberty to approach the appropriate court in case of any damages that is there, Lordship. Just that much.
A file to Sanaba. Is that required?
They were there cultivating that lot of land, Lordship. The possession was handed over way back in 21.
This land is already taken away from you. Then what is left?
However, Lordship, there were damages at that point of
That
time.
for that you have not paid for compensation here.
No, I have not. I'm saying that just the liberty in case this withdrawal should not affect that.
Prays for a liberty to withdraw prays for a liberty to withdraw the present writ petition. Prays prays for withdrawal of the present writ petition with liberty to approach the respondent authorities for raising any grievance if so arises in the any grievance. Because I was about to, you are not filed even a rejoinder. I was about to have prepared it for disposal. Ms. N. Begum, learned counsel, appearing for the petitioner, submits on instruction that she be prays on instruction that she be permitted to withdraw the petition with liberty to approach the appropriate authority for redressal of her grievance, of the grievance of the petitioner. Full stop. The prayer is not objected to by the learned counsel for the respondents. Full stop. The writ petition accordingly stands dismissed with liberty as prayed for. However, it is provided that any such application made by the petitioner shall be so made, if so permissible under law. Supreme Court matter is pending or disposed of?
My lord, because that was submitted by Mr. Kayal. And
Where is Mr. Kayal making? Because there is a
in bar, he was telling me that it is not covered by the Supreme Court.
not covered.
So such a matter is not pending because of.
Then why did he make his submission here? Can you get him? And they have not even cared to file a reply also.
Yes, that's right.
Can you get him? Can you get him? Mr. Bhatti, please have a seat.
Yeah.
The bill follow. Who is appearing for the government?
Central government.
Central government?
Yes.
Parasar, what happened?
Lordship, we have sent mail for instruction.
I'm sorry, the mail was sent, the instructions were sent on 10, documents were sent on 10/1/25.
Yes, Lordship.
What happened?
We have sent mail on February 1/25.
What happened? Today we are in May.
Instruction has not.
I'm sorry, this is not done. This is not.
7 days time may be granted, Lordship.
We have granted you 4 weeks time. You have sent it in February. You don't have any instruction till date. Pension matter. The lady is waiting. If she is not entitled, reject it. Finished. End of the matter.
Lordship, 7 days.
Day after tomorrow. Where is Mr. Parasha?
He's on next.
Call him. Let Mr. Parasha come. If you are not entitled, not entitled. That much only you have to say. That the lady under that scheme is not entitled. You are married.
No.
But see, that pension was given. This is not a regular pension. This is that Swatindra
Freedom fighters pension.
freedom fighters pension was given to the wife. And that is how she is claiming.
The state pension has been given to her.
Ah.
It was
Oh, state pension. Get your instructions. Ask Mr. Parasha to please.
but contractual dues are about 8 lakh remains. Others have been paid. Right?
Yes. But they have filed an affidavit here, additional affidavit. They have said that you have not completed certain part rectification.
But that's not correct because let's
Have you file a rejoinder to this? How can I go beyond this?
they've already paid 90%. Only the security deposit is left. That's the only thing.
Bills have been cleared.
Clear. The 8 lakh security deposit is left. That's the only thing.
Only SD left.
Hearing on behalf of RB Bora for BTC Lordship.
Huh?
RB Bora.
Ah. Madam is here. Yes, madam. Anything? This is central government.
Well, it's not central government that you know, it's
National Science Center, Guwahati.
yes.
It is the amount of only 8 lakhs remain lots.
Ah, why?
It is to be lots of PWD lots, PTC, PWD.
Yes, madam.
So we have received one instruction.
Some rectification work is here lots.
That is the affidavit.
On rectification, the remaining amount will be released.
In fact, I had submitted a reply, madam. I had only 5.
Your file, it's not on record. Your name? Miss S. Boro, Learned Counsel, appearing on behalf of Miss R. B. Boro. Boro, Boro, Standing Counsel, Bodoland Territorial Council, prays that she be granted a week's time to complete her instructions in the matter. Full stop. On the next date of listing, the Learned Counsel for the respondents shall apprise this court as to the exact reason for not releasing the remaining pending dues of the petitioner. The petitioner has contended that the only reduce receivable by him now is the amount pending against the security deposit head of account. Get it?
Oblige.
It will be.
Please, your loss. The lawsuit
Hmm.
was the last order. The instruction was for the department.
Yes, yes.
Yes.
That is in terms of my application before the circle officer.
Now tell me, your father had given this land.
Yes,
Was there any condition there that it will revert back to you?
actually that Krisi Sarsa Mandal.
That is gone.
That
That
committee-
land will be government land now.
No, my lord.
But that
land
has,
is-
your case is that it has been now mutated in the name
Yes,
of
yes,
that
my lord,
secretary's
private
children.
respondent.
Yes.
So I filed an appeal before the deputy.
Yes.
So it is the appeal, lord.
Why? From 23, this instruction has not come. Small issue. I find somewhere that you have also, there is an affidavit from 4 to 8.
Yes, fine.
You say you are in possession,
Yes, my lord.
but they are threatening you.
They have paid, they have paid.
But they say that they are also in possession.
Yes, my lord. At, in my repetition at para 66,
Hmm.
65.
Hmm.
That is the report.
How was this mutation done on the basis of inheritance?
That is on the, they claim to be the inheritant of the,
No. Mutation in the Chitta, it was done by way of inheritance.
yes, my lord, that mutation, your lordship will find. উত্তরাধিকারী করতে
Uttradhikari. Yes, how?
পরে টেনে
Mr. N. Goswami, learned counsel, appearing for the respondent number 2 and 3 submits that he would complete his instructions in the matter on by the next date of listing and apprise this court as to the stand of the respondents represented by him in the matter. Full stop. Registered to list this matter again on at a date. 20 तारीख माने 22nd by 22/5/2025 on the next date of full stop Malay. You get your instructions.
of like. I am appearing for respondent number 5.
Why have you stopped the learned counsel for the petitioner to come to court? Huh? It seems that because of you, he is not coming. Interim order rejected. Interim order rejected. Exonia land. Right?
Okay,
We'll wait for some more time.
we need some time to file our affidavit.
Oh, you want to file? You want to give them a lease of life? Okay, fine. I was about to dismiss it today. A prayer is made on behalf of the learned counsel for the
Respondent number 5, your lordship.
respondent number 5. Your full name?
I'm KJ Saikia, your
KJ Saikia.
on behalf of Mr. AK Gupta.
Mr. KJ Saikia, learned counsel appearing for the respondent number 6, submits that he be granted 3 weeks' time to bring on record the stand of the respondents represented by him by way of filing an affidavit. Who's up? Prayer accepted. Registered to list this matters again after 3 weeks on a date to be fixed by.
Deeply okay.
Now you are in the correct case.
Also, last time I have taken time to file rejoin the affidavit, but otherwise, the issue has been settled by Supreme Court in RM Service Center.
Give me. Yes, what is your case?
They are supposed to file reply.
They are not filing reply.
Oh, that's
I sent it for vetting. I have the draft affidavit.
Sinner lead the case, lordship. Sinner lead the case, lordship.
Huh?
Sinner lead the case, lordship.
This is also followed in the license has been option from
86, lordship.
para 14 minutes.
Para?
Para 14 minutes. The motor speed and high speed diesel order is mandatory or not? Madam?
Some foreign fittings were found
Yes,
in
ma'am.
the.
And we have followed our own guidelines, kind of the marketing discipline guidelines.
No, he's without his senior,
Yes.
so we'll not put him into trouble. Mr. D. Day, learned counsel for the petitioner. submits that heard Mr. D. De, learned counsel for the petitioner, also Mr. S. Bhattakur, learned counsel appearing for the
That's not 2 to 5, my.
2 to 5, and Ms. U. Das, learned additional senior government advocate appearing for the state respondent, respondent number 6. Also, Mr. Bhattakur submits that the affidavit on behalf of the respondents represented by him,
Or reason the affidavit.
rejoined affidavit on behalf of the respondents represented by him would be filed invariably on or before
20, madam.
2/05/2025. Mr. Bhattakur has further submitted that the issue arising in the present proceeding is covered by the decisions of the Honorable Supreme Court in the case of Indian Oil Corporation Limited and others versus RM Service Center and another, reported in 2019 SSC 662, and in the case of Hindustan Petroleum Corporation Limited and others versus Dharmanath Singh and others, reported in 2024 SSC Online SC 987. So accordingly, registry to list this matters again on
After 24.
27/5/2025. No. 27/5. 27/5. Okay. Yes.
But you accept the Delhi High Court judgment, I do not have any method of material. I leave it to your lordship. But your lordship may kindly peruse the Delhi High Court order for a moment. Because after finding of the affidavit in opposition by the respondent number 1, and after perusal of the affidavit, the Honorable Delhi High Court passed the stay order, lordship. It is not that the stay order was passed in the motion stay,
I only want one clarification.
lordship.
Show me any document that it is a examining body and not a institution wherein you can appear in the examination. There is a difference.
Yes, absolutely, lordship.
SEBA,
Yes.
Assam Higher Secondary Education Council, and a provincialized higher secondary school. I just want to know whether this institution is a provincialized higher secondary school or it is the Assam Secondary Education Council. Because Assam Secondary Education Council, through the National Open School, they also conduct classes.
Yes.
Do you get my point?
Yes.
But a provincialized higher secondary school or a senior secondary school cannot give a certificate.
Absolutely, lordship.
That certificate can be given by a,
By the board only.
so you just show me that much only. I want.
That material, lordship, at this stage, I will.
Then, where is Mr. Gogoi?
In fact, their affidavit also says that the registration process will be the outcome of the, subject to the outcome of the reputation. Pending.
Okay, we'll adjourn it. Nobody is here. Patat Sata tomorrow.
And that matter is.
As prayed for by the Learned Council for the petitioner, registry to list those matters again after 6 weeks on a date to fix by. All right. Mr. Chaudhary,
Yes, Lordship,
why have you excluded him?
the exclusion has come to light only in January,
Ex-
when I was made a party.
Okay,
Because the state says that the center is now, I don't know what is the stand of the state.
no, the stand of the state is that a list was prepared.
This was prepared.
Then, as per the changed policy or the procedure, geotagging is done. And then a fresh list is prepared by you.
That is one.
Hmm.
I don't know what is urged by the state. I am requesting for 2 weeks' time. Let them give me a copy of their, what is their stand, because in the petition, I am in the dark.
No, the petition, nothing is there. You'll have to go to their affidavit.
Yes, that is one.
There are 2 affidavits. 2 affidavits.
Yes, Lordship.
They have said everything. But why his case was not included, that much only they have missed out. And they put it on you.
That I should know.
They have said everything. I have a good idea as to how the Pradhan Mantri Awas Yojana schemes are prepared. That very good idea. I liked it reading it. But the only thing I don't find which is material for me is why he was excluded. They say they don't. It is you. So you are the culprit.
No, that my friend has.
Right?
told me.
Yes, yes.
But they're ready to be. I made some allegations. Some person earlier get benefit, again they say
Mr.
that
Ahmed,
we are going to.
Mr. Ahmed, you
Yes,
stick to
yes,
your
and no.
thing. Why are you going for others?
No.
Let others have a house. If you have a house, you will get a house.
Yeah, but I,
That much only.
but their
Mr. Ar-
position is, my lord.
For those allegations also, I have replied, my lord.
Oh,
They
we are
reply,
not
they
going into
say
that.
We going to exclude
Let-
their
let
We are
name.
not going into that.
If they
We are
exclude
not
their
going
name,
into that.
why they cannot include our
We
name?
only want to know why your name was excluded. If it is genuine, out. If it is not, we will direct. And there is another stand taken that once an list is finalized, there cannot be any addition. Only removal is permissible.
They say they remove those irregularities. Why did not they included the genuine persons, my lord? It is
Disputed,
their strength.
Mr. Ahmed, disputed questions have come on record.
Yes.
Why should we go into? Satisfy me. No, satisfy me. Why should we go into? If you're arguing, satisfy
No,
me.
my friends.
This is what I said. We also burn midnight oil. Don't worry. That is the only thing I want to know. Mr. RKT Chaudhary, Deputy SGI, submits that he submits that he would apprise this court about the stand of the. He would complete his instructions in the matter and accordingly praise that. Mr. RKT Chaudhary, Learned Counsel, Learned DYSGI, appearing for the Union of India, submits that he be granted 2 weeks' time, 3 weeks' time to complete his instructions in the matter. Prayer is not objected to by the Learned Counsel for the respondents, for the petitioner. So, the Learned Counsel appearing for the Panchayat and Standing Council, Panchayat and Rural Development Department shall furnish copies of the affidavits filed by the departmental authorities represented by him to Mr. RKD Chaudhary for his reference. So accordingly, registry is directed to list these matters again after 3 weeks on a date to be fixed by.
So that may be.
We are here. Yes, Mr. Vati.
So for item number 12 is concerned, my lord, the junior road is taking
Yes,
You have received instruction, Lordship, allow us 1 week time.
I want to know what is the Supreme Court case pending. Because there is a submission that Supreme Court is pending, so we have adjourned the matter. Why? And he says there is no such case pending.
Well, Lordship, now he is on legs in court number 24. Kindly pass over the matter for time.
Yesterday, this brief was not given to him in the chamber by you. Oh, you were not there.
My lord, let it come any other day.
As agreed to by the Learned Council for the parties, registry to list this matter again on when, Mr.
Next week, man. If possible.
On 16/5/2025. On the next date of listing, Mr. Karnalak, not cut the meeting. I'll not put him into more trouble.
Madam.
I'm your bless.
Yes. Anything? Yes.
Please to take up the transfer of property exclusion.
Transfer of property, TP Act to do it.
Transfer of property.
Transfer of property Act.
Short judgment, my lord. I am relying on paragraph 5. With your lordship's kind permission, may I read it? my lord? N. Khazuddin versus my lord, Tamil Nadu Khadi, Manupatra, my lord. Paragraph 5. The moot question which arises for our consideration in this appeal is whether the registered gift deed dated so and so was duly acted upon and accepted and is a valid document which continue to exist despite its revocation on so and so, as the donor had not reserved the right to revoke the same. Lordship will kindly mark this. Then paragraph 6. The registered gift deed dated so and so is exhibit 1. There, my lord, a suit was, my lord, filed, instituted. It has been executed by the defendant appellant. A perusal of the gift deed reveals that the donor has gifted the suit property in favor of the plaintiff respondent for the purposes of manufacturing of khadi lungi and khadi yarn, etc., with the condition that the plaintiff respondent shall not transfer the suit property for his own self-interest. The gift deed stipulates that neither the donor nor his legal heirs have any right or interest or will continue to have any right or interest in the suit property from the time and date of the gift deed. The gift deed further states that the gift is with full consent of the donor and that from the date of the gift deed itself, the plaintiff respondents accept the suit property for the use as aforesaid. Now, Lordship will kindly come down, my lord, to paragraph 11. Previous time, my lord, only observations finding. Now, the question arises as to whether the aforesaid gift deed has been validly revoked by revocation dated so and so. And if so, what would be its impact upon the rights of the plaintiff respondent in respect of the suit property? Then paragraph 12. No doubt, the gift validly made can be suspended or revoked under certain contingencies, but ordinarily it cannot be revoked. More particularly, when no such right is reserved under the gift deed. Lordship will kindly mark this. I will make an attempt, my lord, to distinguish, my lord, on the facts. In this connection, a reference has been made to the provisions of section 126 of the Transfer of Property Act 1882, which provides that a gift cannot be revoked except for certain contingencies enumerated herein. Paragraph 30. It is important to reproduce section 126 of the Act, which reads as follows. Section 126. When gift may be suspended or revoked, the donor and donee may agree that on happening of any specified event which does not depend on the will of the donor, a gift shall be suspended or revoked. But a gift which the parties agree shall be revocable wholly or in part at the mere will of the donor is void wholly or in part as the case may be. A gift may also be revoked in any of the cases, save one or failure of consideration in which, if it were a contract, it might be rescinded. Save as aforesaid, a gift cannot be revoked. Nothing contained in this section shall be deemed to affect the rights of transferees for consideration without notice. Then, my lord, paragraph 14. Section 126 of the Act is drafted in a peculiar way in the sense that it contains the exceptions to the substantive law first and then the substantive law. The substantive law, as is carved out from the simple reading of the aforesaid provision, is that a gift cannot be revoked except in the cases mentioned earlier. The said exceptions are 3 in number. The first part provides donor and donee may agree for the suspension or revocation of the gift deed on the happening of any specified event which does not depend on the will of the donor.
Got it.
And then, my lord, paragraph 15, 16, non-utilization. Then, my
Literally
lord,
the three
paragraph 20.
circumstances wherein a gift deed can be revoked
Yes.
has been brought on record.
Now, one thing which falls out from the statutory law as well as from this pronouncement is that, my lord, there has to be a specific clause and that
Incorporated.
it has to be specifically worded as such, my lord.
Where,
That has been-
have you gone through the gift deed?
Yes, I do not find as such. So therefore, lordship, at the first instance, may be pleased to come to the first gift deed. There are 3 gift deeds, my lord. There are 3 gift deeds. The first gift deed, lordship will find at page 23, annexure 1.
Mr. Chaudhary, we are just trying to understand. We'll not take any call on this. Don't worry. Yes.
Annexure 1, page 23. I see Kondopo Narayan Dev so and so, do hereby execute this deed of gift in favor of late Kali Krishna and also Balika Vidyalaya Hodai, represented by its secretary so and so. Then the second paragraph. Since Hudai town so and so accordingly in response to the local public request, I hereby donate my own below scheduled land measuring 1 bigha on which I have all the rights, title and
Come to
possession.
page 24.
Yeah.
1, 2, 3, 4, fourth line.
Yes, the school, after elevation of the school, if the authority wants to change the name, then the donor or his heirs will have the right to cancel the mutation of the school. Kindly mark, Lord, this my lord. Mutation of the school on the said land and take back possession of the land back as per the terms and conditions of the gift deed. Now, what happened, my lord, in the apex court decision was that, my lord, there was no specific revocation clause there.
Here there is one.
No, this is not a revocation clause per se. This speaks
Okay.
about. This
You
speaks
mean to
about the
say
con-
revocation of the gift itself?
Gift deed itself. The, my lord, the tenant has to be, my lord, first of all, my lord, altered. Then only, my lord, consequences which can be altered. Mutation is a consequence of, my lord, the
And in all the 3 gift deeds, this is the prescription.
similar language, same language. So mutation is a consequence. On the strength of the gift deed, my lord, the donee becomes the absolute owner, having right, title, possession. Because since, my lord.
Any other decision?
No, this will suffice. Now,
You go through this.
My lord, I have gone through that decision.
and
My lord, the agreement has to be read harmoniously.
Hmm.
The basic purpose of the agreement was to donate the plot of land for a girls' school,
Hmm.
and the name of the school should be so and so. And if that name has to be changed in future, in due course, for any other reason, it is not dependent on the.
That
mere
is
the
what Mr. Barpujari, if I've understood him correctly, what he is trying to say is that a gift deed can be revoked,
revoked, correct.
but that revocation has to be incorporated in the language of the gift deed. Now, what is incorporated here is not the revocation. It is the cancellation of the mutation.
Mutation, correct.
So that cannot be a revocation.
The spirit is there. Spirit is
That
there
we
for
will
the
have to
gift.
consider whether that will also amount to a revocation of the gift deed
Correct.
itself.
Understood.
because in this apex.
A little bit open now.
I am always obliged, my lord.
Mm.
Well, in the apex court decision also, this was the issue, similar, identical issue. There, my lord, there was no specific revocation clause in that gift deed. And my lord, what was written in that gift deed was that if you do not use the property other than for manufacturing khadi items, it will, my lord,
Revert back.
it will revert back.
Similarly as this.
Yeah, Supreme Court said that no, you cannot revoke it. Then lordship, for my
Mr. Chaudhary, we have now got the counters, how much we can go. Make your submissions. We'll
One of my
consider.
submission is that the agreement has to be understood in its spirit. The purpose of the gift deed was for the school land, for the school purpose. Now circumstances happen such like that. It is not dependent on the mere will of the donor, neither on the donee, but circumstances have become like that the school got amalgamated with some other school. And the name of the name-
Basically, it is the name which is
not there.
the
Name is not there.
prominent factor in the
Name.
gift deed.
If the prominent.
Like,
factor was name.
gift deed, the basic reason
Not
for
the
giving
usage.
is that the name should be always maintained.
Not the usage.
meaning thereby they wanted their legacy to be continued.
That's it.
That much.
That
as
is
simple as that.
a very
And
good wish of a son that he wants his father's legacy to continue.
Magnanimous endeavor.
Very, very.
Magnanimous endeavor.
and
But whether now, because of that, whether that will revert back to the petitioners or not, that's the issue.
Section 126, Lordship has said it. It is specific, my lord. It is in no uncertain terms, my lord. It has been drafted in that way, my lord, which the apex court has relied upon.
Apex Court has also in this decision explained what is 126.
Yes, exactly, exactly. And for the time being, if
And
Lordship
here the only thing we have to consider is the first part of 126. The later part will not come.
later part, and there is one another provision in the TPA itself, which also is taking up the TPA. Lordship may kindly come to my lord section 6. Because 126 is a special provision, my lord, called out in the act itself relating to gift.
Mm.
Section 6 is the general provision.
Okay.
Kindly see, my lord, section 6. Section 6 says what may be transferred. Property of any kind may be transferred except as otherwise provided by this act or by any law for the timing in force, my lord. Then lordship will kindly come to B.
B.
6B. A mere right of re-entry or breach of a condition subsequent cannot be transferred to anyone except the owner of the property affected thereby.
Okay.
So this puts
Now
a
that
bar on the
put-
reversion.
Okay.
This puts a bar on the.
They are not the owners.
They are no longer the owner. But the bar is created. Nonetheless, even I'm not going to that extent because my lord, generally was specially was not
So
affected.
now
The general provision
Okay,
will have to give
okay,
way to the
okay,
special.
we
But I
got it.
myself to 126 itself.
We got it.
Yes,
Now, under such circumstances,
my lord.
he has a grievance. He has a grievance. If he has a grievance, there has to be a mode of redressal.
Yes.
Whether writ court is a mode of redressal.
Absolutely. Therefore, lordship will kindly come to page 20 of the writ petition. What is the relief sought for? Where? Page 20 of the writ petition. I am making my submission, my lord, not as an adversarial.
No. We are trying to, you're trying to assist me, that's all.
Kindly see, my lord, the first prayer, my lord, a writ in the nature of session so and so shall not be so to cancel forbear from giving effect the order. Now, this order dated 15/6/2023 is a consequential order, whereby that order lordship will find, my lord, at page 52. 52 of the writ petition.
12/6,
Yes.
15/6.
15/6. For smooth, this is an order passed by the additional deputy commissioner in charge of the subdivision for smooth functioning of official work so and so. The Kali Krishna Adarsa Balika ME so and so has been amalgamated, and thereby the buildings of the schools has remained unutilized. Therefore, the above mentioned school is hereby temporarily allotted for setting up of a employment exchange office.
Mr. Chaudhary,
Right.
where is your claim? Where is your claim for establishing you as a owner of that property? You have not made.
My point is simple, my lord. My point is.
No. I got it. But where is your prayer that the deed, having lost its purpose, has to revert back? Land has to revert back. The mutation in favor of that school has to be cancelled. Have you moved for cancellation of that mutation of the school?
Not yet. We have not moved.
This is premature then.
We want the office to be closed down and.
That you can do once it comes back to you. Still, you may have a right to that, but the land has not come back to you. And you have not even moved in that direction. Yes, how can that be?
My lord, we have.
I would have understood a case wherein you are claiming that because of the cancellation or the purpose of the deed having lost its force, the land has to be directed to be settled with you. You had approached the government that cancel the mutation with that party, school, and mutate it in my name. But there is nothing here.
There is a representation, my lord, earlier.
Representation. Okay, let us see what is the representation. Page
53. Annexure 6. In the first
Okay.
paragraph, third last line.
Now, this representation will also, in my respectful submission, is redundant. for the simple reason, there has to be a declaration from a competent court of law that.
This is not.
Right, and that declaration.
Mr. Chaudhary, why are you spending time here?
I will go to civil court, man.
You withdraw this, go before the civil court, get your rights. Huh?
But regarding the employment exchange, my lord, I don't want it.
That-
there. Employment exchange, temporary employment exchange, I don't want it there. My lord.
You don't want it?
I don't want the employment exchange there, temporary.
That is, you will have to first
That is good.
get yourself into the shoes of the owner. Then only withdraw it to explore the avenues available to you. After arguing the matter, Mr. Barbujari, thank you for your assistance.
I am always obliged.
Mr. B.D. Chaudhary, Learned Counsel for the petition, after attempting to argue the matter at some length, has submitted an instruction that he be permitted to withdraw the present petition with liberty to the petitioners to approach the appropriate forum for redressal of their grievances. Prayer is not objected to by the Learned Counsel for the respondents. Accordingly, the present writ petition stands closed, not dismissed, on withdrawal.
Then, my lord, the highest law of limitation will come as a barrier for him. If
My lord,
lordship
only-
dismisses this matter. Anyway, my lord, close.
At that point of time, the drafting of the agreement was bit wrong.
Now,
In 1966,
I liked one thing what you said, spirit,
spirit of the agreement.
because that intention was that only.
That intention was there, my lord.
But it was not put in so many words.
It was
The
not-
Supreme Court judgment may find out there
That
may
was
be
very
some
clear.
others.
That I have also read. Forbidden, and that is the only judgment that till date, only
This is
judgment
there.
which specifically states.
I did not know, so I know now. I'll have to read it nicely.
It is just like will, my lord. If in a will, my lord, the name of the executor is not mentioned,
Finished.
finished. End of the matter. That's
That
how.
was a technical-
That I had an experience in Arunachala matter. Literally, somewhat I could get to know what a probate is.
That
Very
was a
strict, my
technical
lord.
defect in the agreement.
Huh?
That was a technical defect in the agreement.
They-
That I accept. That on the very.
Mr. Chaudhary is very fair.
No, no, therefore, I have my lord, at the
It's very
opening of
fair.
my submission, my lord, I am making the
Not today.
submission as an officer of the court.
No, not today, but we know, I know him from when he
Yes,
started.
my lord, I am always grateful to him, my lord. I am always grateful to him. I always look up to him. my lord.
Okay.
I am so obliged.
Yes. Where is the government? It's a dispute between the brothers. You say you are a pattada,
Yes.
recorded
Agreed
pattada,
also.
but you have not been paid the money.
Man,
You have been kept out. Yes, what is your case, Mr.?
Lordship, so far, my lord, mutual agreement between the, he and me. And there is a note, my lord, written by himself, my lord. That therefore I file a lie, to be in opposition, my lord.
That is different thing.
And now, my lord, the,
Now there is a dispute with regard to apportionment of, go before the competent authority.
That is what our case is, that is land acquisition officer has traveled beyond its jurisdiction. When there is a dispute, land acquisition could not have decided it. The option was to refer to the court. That is not done.
Reference code.
Yes, that is not done, and this order has been passed, rejecting our claim. And the entire amount has been paid to him. This-
Already.
Yes, already.
already paid prior
So,
to filing this,
My humble submission, lordship,
prior to filing the petition, lordship.
is
The amount already been disbursed prior to filing the petition.
Fine.
And now, my lord, already I received, my lord, and here, my lord, right title interest cannot decide by this only. Right title interest over paragraph
This
12
reference code
concern.
also cannot, this.
Right,
land acquisition
that
You
officer
see,
cannot-
Kala also cannot, it has to be by the reference code.
Yes.
Lordship.
Yes, Mr. Goswami. You are the one or Mr. Bhattaji is the one? Then what happened here?
Now, lordship can write to refer to it.
Now, I want you to know why you have not referred. Now the money is paid. Okay, fine, we can wait for some more time. why the matter was not referred when he raised the dispute? Or is it your case that he raised the dispute after the money was released? I don't find that to be here. He was before the competent authority, I think, when the whole thing was started off. Yes, Mr. Bukhaisal?
Yes, sir.
My lord,
And why your instructions are not on record?
may I submit one thing, my lord. So far sanction order dated 7/6/2023, money disbursed.
Okay, fine.
And so far the complaint, nothing disclosed regarding this disbursement.
His only case is he's a patadar with him.
But his portion was mutually agreed. His portion already acquired.
But his name still continues in the
But mutually, my
record
lord,
of
my
rights.
part acquired, when my part acquired, he come. But he's also,
His part is still there.
no,
no.
already mutually agreed upon, share already divided.
Okay.
And
How
my,
much is the land?
on the basis of.
How much is the land total?
2 kotha 18 lasa.
What is his share?
But he is not involved in this share. Because
There is no
his
party
share
powers.
already taken. And my,
Out of this 2 katha, he has got no share.
no share.
He has got some other land.
Other land.
That is
And
that.
on
There
the
is a
physical-
family
on the-
declaration to that effect.
On the physical verification and regarding Mondal, everything, Gaubura, all this was present. And there was a hearing conducted. And so far this order passed by law 29/9/2023 and nothing wrong. There was a my lord hearing, proper hearing and mutual understanding also there and physical verification. I was in physical position and he's in position, his part.
That
And
is the
when-
dispute, Lordship.
When my part acquired, he come to. Yeah, he's also entitled to get.
Okay, you get your instructions, Mr.
There is
Awesome.
no partition.
But he
Oh.
says there is a family partition.
No,
Family
that
settlement.
is a dispute. That is, we have lost case also. They have annexed a unregistered document.
Okay. Your signature is there.
Yeah,
He
it is
has
not my signature. I
You
will
have
show the
disputed your
different
signature.
also, yes.
Mr. N. Goswami, Learned Counsel, appearing for the respondent number 234, submits that he would complete his instructions in the matter on or before the next date of listing and apprise this court of the stand of the respondents in the matter. Of the stand of the respondents represented by him in the matter.
These books for you lost
Oh, thank you.
for ready reference.
Thank you.
And I relied upon my lord here also one judgment.
And the book, the
2015
beauty is not the book, but the name. Name of the author. क्या लिखा है? Of the stand of the respondents represented by him on the next date of this thing. Raised it to discuss matters again. A 26, 28, 5/2020. We'll see on the next.
20 of this.
I only want to know why the matter was not referred to the reference court.
They have decided the issue.
That they cannot.
That they cannot.
I just want a clarification from. Then we'll see.
Obliged.
Heard, Mr.
Lordship, before Lordship process, Lordship, for my satisfaction, kindly peruse page 76 for a minute.
70?
6.
Huh.
And Lordship 72, Lordship, though I do not have any claim, Lordship, but my name was not regularized due to the oversight of the respondent authority, Lordship.
Can't help it.
Yes, Lordship, that is- I
Heard,
have come
Mr.
lately.
We'll allow your review petition on the ground that you were having some personal inconvenience on that day. That much we'll do. Heard Mr. S.N. Krishna, Learned Counsel, for the review petition. Also heard as Boro appearing on behalf of the respondents number. Appearing on behalf of the respondents number
7, 8, 9.
7, 8, 9, 9, 13, 14. Mr. N. Upadhyay, Learned, appearing for the respondents number 4, 5, 10, 11, 12. And Miss A. Sharma, Learned Counsel, appearing for the respondent number 6. Mr. A. Chalia, Standing Counsel, appears for respondent number 2. Any government advocate? Mr. Goswami. Mr. Goswami, N. Goswami, learned government advocate, appears for the respondent number 1.
2 and 3.
1 and 15. Usko upar mein lagna, particularly. The present review petition has been instituted by the petitioner praying for recall of an order dated 14/11/2024 passed by this court in writ petition number WPC number 2490/2024 on the ground that on the date when the said matter was taken up for hearing, the counsel for the petitioner could not remain present in the court on account of why?
Some family function is there in my.
On account of certain
place, Lordship.
religious rituals which were being performed in his house. And it is further submitted that a letter of absence was also submitted. Where is your letter of absence?
Lordship, at page 115, Lordship, last page.
Letter of absence
Serial
was
number
also
31.
submitted, and the absence of the learned counsel for the petitioner was also reflected in the cause tracking. It is submitted by the learned counsel for the petitioner that this court was not apprised of the fact that the learned counsel for the petitioner was on leave on the date when the writ petition was taken up for consideration, and accordingly, in the order dated 14/12/2024, it has been recorded as none has appeared for the petitioner on call. He submits that the learned counsel for the petitioner submits that he, on account of his absence due to pressing reasons, he was not in a position to assist this court in consideration of the issues arising in the matter, and accordingly submits that the order dated 14/11/2024 be recalled and the writ petition be restored to file. Prayer is not objected to by the learned counsel for the respondents who have submitted that the petition was prevented from appearing before this court on account of genuine reasons, and his leave was also reflected in the cause list published for the said day. Full stop. In view of the above position, this court is of the considered view that the order dated 14/11/2024 on review is required to be recalled. Accordingly, the order dated 14/11/2024 stands recalled with further direction to the registry to restore the writ petition, connected writ petition being WPC number 2490/2024 to the two records. Full stop. Registry to list this matter again on registry to list the writ petition, WPC number so and so on writ petition to log on (15/5/2025). Full stop. As agreed to by the learned counsel next writ petition again. As agreed to by the learned counsel for the parties, registry to list this matter, writ petition. In view of the order passed today in review petition number 20/2025, and as agreed to by the learned counsel for the parties, registry to list this matter again on 25/2025 for further hearing. It will begin. No, I did it.
Deeply obliged.
I've done it. Now I'll write hurt and then the same order will follow.
Yes.
Yes, Mr. Kumar. Finally, I have you.
Yes.
Yes. How much? How much?
Lordship, we have filed a affidavit.
Nothing is it.
There is the,
Nothing is it.
that there is a.
If I have to go deep into it, it'll be very bad.
And your lordship, otherwise also your lordship, this writ petition is not maintainable
Why?
because it is hit by delay in licensing. So the cause of action arose in the 14 itself, your lordship, he preferred this writ petition in the year 2022, your lordship. The inordinate delay, there is no explanation, absolutely no explanation. And in the meanwhile, your lordship, the third party interest has been created, your lordship. And even your lordship, can you say in the 2019, your lordship, SLC rejected his proposal.
Okay.
Even then, he never challenged it. your
Seema Dev, no? Respondent?
Yes.
Seema Dev was appointed only on 18/11/2021.
That's a different cause of action, but so far as
Okay.
the SLC recommendation, your lordship,
Okay.
it was never challenged.
Okay. We will consider your thing.
Lordship.
So you want me to go into the merits of the matter?
Your lordship, I have filed the affidavit on the
Huh.
facts, your lordship.
Huh.
And
And then we will go into the total merits. We will go into the appointment of Seema Dev also.
your lordship, since our case is there, since this writ petition is itself not
Okay,
maintainable,
fine.
then
I'll dismiss it, but I, as a court of equity, I'll also have to look into the manner of appointment of the private respondent.
at the instance of the writ petitioner, your lordship.
No, it has been brought to my notice. I have that power.
Your lordship, kindly in this, in such manner, your lordship, I would like to place one Supreme Court decision.
Huh. Welcome. What is it? Give me the citation.
Your lordship, 2009 1 SCC 768.
Party?
Party Tridip Kumar Dingal and others. Versus State of West Bengal and others.
What is the ratio? What is the decision? What is the point?
Point, your lordship, they will get it in paragraph 57 and 58 and 59. May I read, your lordship, the 11 paragraphs. If the petitioner wants to invoke jurisdiction of a writ court, 57, your lordship. This should come to the court at the earliest reasonably possible opportunity. Inordinate delay in making the motion for a writ will indeed be a good ground for refusing to exercise such discretionary jurisdiction. The underlying object of this principle is not.
Got you, Mr. Kumar. Got you. Need not trouble yourself. Then,
Last paragraph, you would say 59.
I've seen it. I've seen it. Next,
And another judgment, your lordship, which is the 2023 SCC online Supreme Court 219, your lordship.
Devabrata.
Your lordship, paragraph 36, 37, 38, 39, 40, 41, 45.
36, 37.
38, 39, 41, and 45.
Okay. If you are relying on Devabrata,
Yes, sir.
also satisfy me. Devabrata says that neither you can consider nor this court can consider after a delay. The husband of the when is the husband of the
In 2013.
after 6 years, how could you have appointed? Where is that compassion after 6 years?
Your lordship, if the state has given some benefit, is it the ground for the
No.
petitioner?
You have yourself withdrawn the benefit following Devabrata Tiwari.
Your lordship, this is a subsequent development. Your lordship.
Either as
Just
it may,
24 only. they-
either as it may,
it
that
is
is
issued.
because
On
because
20
now the
in the
time
year
has gone
24
8 years.
State has adopted a new scheme.
Okay, next,
Following the-
next.
In this two, Rajan, I am relying.
But Mr. M.R. Adhikari, Lana Counsel for the petitioner, also heard Mr. You want to submit something?
On the point of delay, that SLC meeting took place on 3/10/2019, but I was never informed about that. Well, my case was rejected. I ought to have been informed that yes, your case was considered by the SLC, but it was rejected. It was only after Sima they joined, I came to know. Immediately after, I put
Your submission is SLC was on
3/10/2019.
It is not used. There is no such pleading.
but today the submission of Mr. Kumar
Right.
has meet.
On the point of delay.
Today, till today, Mr. Kumar was defending. Today he has attacked.
He's
So be
aggressive.
careful. Till today, because maybe I was attacking him, so he was also defending. Today he has attacked. These two judgments we cannot ignore now. We'll see. But Mr. M.R. Adhikari, counsel for the petitioner, also heard Mr. P. Kumar. K. Kumar, daily it happens. K. Kumar, learned additional senior government, additional advocate general appearing for the state respondents, assisted by A.K. Ghosh, learned counsel. Also heard Miss A. Sohoria, learned counsel appearing for the respond number. Along heard Mr. A. Bachaji, along with Miss your name. A. Sohoria appearing for the respond number 7. What's up? Registry to list this matter again on on 27th for further hearing. I'll pass the order on that.
All right.
All right.
Sorry, my lord, just have a lordship, my lord. I don't know about 5 to 10, my lord, they may be given. My lord.
We'll give. No, we are passing orders there. If possible today, if not, then only I'll give a date. What I say? Yes. What do you say? He has completed his arguments.
Yes. Lordship, the removal order, page 38. Lordship. The writ petition. Dated 3/4/2021. On the basis of the findings dated 24/02/2021. And inquiry report dated 24/02/2021. On the basis of the proper inquiry, and the record is before me, Lordship. This report was submitted by the inquiry officer, which following all the required proceeding for the interest of natural justice. Now the record. Kindly see the record, which I would like to place before the court.
I'm not on that.
Lordship.
Fine, that second inquiry report is there, but his case is that prior to that you had held an inquiry
Yes.
and you had given it up.
Lordship, to inquiry.
Two inquiries.
Yes, I will on that.
Why? No, you tell me.
Yes, Lordship, this is first and Lordship, if we see the both statement of allegation, it is different, Lordship. First is absent, unauthorized absent for a certain period, and second one is for another certain period.
It's not overlapping.
Yes, Lordship. It is not overlap.
Show me.
Yes.
Where is the first
The record
show
here.
cause
The record
notice?
here. Lordship, I would say.
Mr. Goswami, what is the leave of the first DP?
Yes, Lordship.
Lordship, first show cause
First
notice
DP
at page 20, my lord, annexed.
Lordship, in the record, Lordship, I would like to. Page 21, Lordship, it is 40, PROC 12, 2019. Got it, Lordship?
Page
Page 21.
of the writ petition or
Yeah, no, Lordship, in
Record.
the record.
page
Record of,
21 is the order of the Chief Judicial Magistrate.
No, Lordship, in the record, Lordship.
Huh.
21.
Oh, there is
Lordship,
two records.
there are two files, two records, Lordship. One for 12, 2019. I am on 12, 2019. PR 40, PROC 12, 2019.
Page 21.
21.
Okay.
Yes.
Hmm.
Lordship, in page 21.
Hmm.
It is for the period, Lordship, can you see, with effect from 10/3/2019, without any intimation, and reported his joining on 1/04/2019 without stating any reason of his absence. Again, he was absent from his duty unauthorizedly with effect from 8/04/2019. He was directed to report his joining immediately for the date as
Okay.
his place.
What
of
happened in
posting. Yes.
pursuance to this?
Yes. Lordship, can you see the other record? Other one.
No.
First
Let,
we have-
let us finish up with this.
Yes. Page
What happened?
Yes. Next, Lordship, before
Ex
that,
parte
Lordship,
proceedings were held against him.
yes, page 23, service of the so-called.
Hmm.
Page 23 is the service.
Hmm.
Page 26 of the appointment of the inquiry officer. 26. Page 35 is the inquiry report.
Hmm.
Page 57, dated 12/08/2020, order for re-examination of the case by appointing a new inquiry officer.
That is what,
Yes, Lordship.
how,
Lordship, after going through the inquiry report, the decision was taken that the authority is not satisfied.
this inquiry report is on record here. First inquiry report, page.
Lordship, page 22, annexure 4 of the report.
Where is the reason why a fresh inquiry was required to be
It
taken?
is in 12/08/2020, page 57, order.
No, there is no required, there is nothing here. Only a re-examination. Why that re-examination was required?
Yes, Lordship, because Lordship, if pursuant to the record, Lordship, it appears that the petitioner has not got the sufficient opportunity that to cross-examine.
After this, what happened?
Yes, Lordship. 59.
Hmm.
Service for appearance before the new EU.
Hmm.
61. 04/12 statement of the Gautam Borua and cross. Let's see.
Hmm.
Page 61.
Huh.
Given the opportunity for cross.
He participated
Yes,
thereafter.
Lordship.
Okay, declined it.
Yes.
Then,
61. Statement 61.
okay, got it.
61, Gautam
Then
Borua.
finally, what happened?
63. Another Umesh Chandra Deka. 66. Statement of the petitioner itself.
81 is the inquiry report.
Yes. 81 is the inquiry report. Inquiry report.
Hmm.
And after that, Lordship, second so-called notice was issued. 83.
page 83.
He replied,
Yes, Lordship, 86 is the service report.
Hmm.
89 received on 19/03/2021, reply to the so called.
Hmm.
92 is the order for removal of the service. That is for one part.
Hmm.
It's a separate inquiry for separate allegations, Lordship.
then
Now,
Second
Lordship, 04/2020. 04/2020,
Hmm.
2020.
Hmm.
Page 17, first so much.
Hmm.
Lordship.
earlier one was 12 of 2019.
Yes, Lordship, 19. Before that, Lordship, kindly see the page 1, 2, and 3, Lordship, of the record, of this record. He was arrested, Lordship. He was arrested by the police, and therefore he was unauthorizedly absent. 1, 2, 3.
What happened to the criminal case pending?
So it has been disposed of and he has been acquitted.
Acquitted.
We are not on that, Lordship.
Okay.
After that, Lordship,
Here the leave is from,
Lordship.
absence is from which period to which period?
Yes, Lordship. Page 17, Lordship.
10/3/2020 onwards.
Yes, Lordship.
When were you given bail here? I think in your written statement, written argument somewhere you have indicated that.
Yes, Lordship.
No. When?
Lordship, my case is that the case that has been presented, my lord, this is a second departmental proceeding that has been initiated, my lord. But I have not been dismissed for that, this particular.
Okay, we'll
case.
see.
That-
Then what happened?
Yes, yes. Then page 27, Lordship, reply to the.
What is the final, where is the inquiry report?
What to do with this, my lord? this-
55.
Regarding
Inquiry report,
inquiry report, Lordship. Report is
48.
page 57.
50.
Lordship, inquiry report. Report is that, Lordship, 48.
48.
48.
What is the conclusion?
Conclusion is that found absent, Lordship, unauthorized absent. It is a
Okay.
few days, Lordship. Earlier was the habitual unauthorized absent, Lordship.
So first case, when was the dismissal order in the first case?
Dismissal order, your lordship will find that the last
No, page, date.
Page 92, Lordship. in
No,
the
no, date.
date is, my lord.
3/04/2021.
2021, that is
3/04.
removal order, my lord, not
Ah,
Removal.
removal order.
3/4/2021.
Here only two increments.
Yes, Lordship. Yes, because that's a small period, Lordship.
My lord, that is a separate case altogether. It has got nothing to do with this rate settlement.
Okay. In the first inquiry, you did not participate, right? Ex parte, the inquiry officer proceeded. The conclusion against you is charge is proved. The authorities gave you an opportunity. So for that, a re-inquiry was held.
No, my lord. After the charges were held to be proved provisionally, I was served with a second focus notice to give a representation to say something about the charge.
Then you said,
Then I, my lord, filed my reply.
you said you are not
Yeah.
given opportunity and
No,
all.
not all those things. Here I pointed out that while conducting the first inquiry, some unlisted witnesses were examined. The moment they came to know, they passed this order.
And it was ex parte against you.
expert against you. But even then, the list of witnesses were not examined during the course of inquiry.
But if you are not there, that is final. So they have given you an opportunity, you have accepted it. You did
Yeah.
not object, you participated.
There I participate and pointed out, my lord, that during the first inquiry, where I did not participate, some unlisted witnesses were
Okay.
examined.
Whether that
Then,
unlisted,
I pointed out, my lord,
they
they
held a,
initiated a fresh inquiry again
got it.
by way of annexure 7.
Got it. Now, in the second inquiry, is there any such allegation some unlisted witnesses have come? Or it is okay? Inquiry per se, we'll consider you that. inquiry per se, is there any prejudice costing in the inquiry? Any denial of cross-examination, documents, that nothing?
I did not participate in the first inquiry.
No, second one.
Second so-called notice was sent to me only to say something about the third matter.
Second inquiry, you participated.
Second inquiry, I just filed my reply. My lord.
You have participated, your signatures are there.
I did not examine any of the witnesses. my
You
lord.
decline.
But that part, my lord, the annexer 7, my lord, that they are not entitled to do, my lord. Because an inquiry has been held.
Okay. Where is your statement in the writ petition with regard to the conclusion at page 36 of the inquiry officer that you had admitted to whatever statements were made and you refused to cross-examine? That is at page 36, that is the conclusion. Where is your statement in the writ petition that this is false?
To that I have not said it, my lord. My lord, my
In
case,
the earlier case, Mr. Kaur was attacking, and today, Mr. Goswami he has done his case.
My
Got
lord-
it in here.
my case is that, my lord, during the.
Have you heard what he has said? Huh? Come on Thursday. Prepare.
There has been a.
Because I did not know that you were allowed to cross. I was under that impression even the second one you were not allowed.
But my lord, they cannot initiate the second inquiry, my lord. They cannot initiate the second inquiry once
Okay.
the inquiry
That is-
officer passed an order.
That is your ground. That second inquiry should not, that's the only ground that you have brought on record.
Because, my lord, when I pointed out that there were some procedural lapses while conducting the first inquiry, and on that basis, the inquiry officer submitted the report to the disciplinary authority. There were remedy before the disciplinary authority to correct that, my lord. That
Further inquiry.
procedurally,
Further inquiry.
further inquiry.
But he went
Everything
for a
was placed before
re-inquiry.
the disciplinary authority, my
He
lord.
went for a re-inquiry.
Re-inquiry, my lord. Re-inquiry, the word is there, but a fresh inquiry was done because, my lord, re-inquiry, my lord,
Further inquiry is not fresh inquiry. Re-inquiry is fresh inquiry.
fresh inquiry. Here it is the case, my lord, not a further
Re-inquiry.
inquiry, re-inquiry. Why, my lord? Because had it been a re-examination
Okay.
or a re-inquiry, my lord, that same presiding officer and the same
Mr.
officer would have done the.
Second case, we are not interested. The first one, just make a list of dates
I
along
have
with
the
the page numbers and the thing, and just give it to her. So that I did not go back to the department. We'll examine his plea. Because he has submitted a written argument also to that.
Supported by some decisions also.
Yes, a scare day.
My lord,
Then,
clearly-
my Lord Justice Gogoi's judgment here in the terms of Rule 9.
Why, my lord, that cannot be done because everything is placed before the disciplinary authority. Under Rule 99, it is for the disciplinary authority to pass that order. He can examine it, he can shall pass order considering all the charges, my lord, against the
Yes.
petition.
When can you give it? Monday, Tuesday?
Regarding the list, Lord.
List and the document and what is the content.
Yes, Lord. I will.
Okay, so if you can give it to me, I can have that for, I don't want to carry the records. I'll go through it, and when I'm dictating, I'll have the records from you. Right? Tuesday. As agreed to by the Learned Council for the parties, registry to list this matter again on Tuesday. What's up? Tuesday date, you know? On that day, I'll pass the orders. It will ready to what.
In the name of re-examination, fresh inquiry has been done.
One factor. There were outside witnesses,
Unlisted.
but-
witness.
unlisted witnesses. But there is a power of the inquiry officer to call. You were not participating. And there is a decision of the Supreme Court that if you are not participated, you know the date, you have not come, then the subsequent dates also need not be communicated to you.
Lord.
But they send you the inquiry report. Maybe you pointed out, they found that no, this is a lacuna, because the interesting factor difference in your case and the other cases is, in your case, there was a conclusion of guilt by the inquiry officer. In the other cases, in the first inquiry, he was exonerated. Be it care dip, be it the decision of our High Court. In all those cases, he was exonerated. Second inquiry, they had found him guilty. Then this court went and said that no, further inquiry permissible, re-inquiry not permissible.
But my lord, in Molloy Bora's case, it has been stated that rule 9 is, my lord,
We'll see.
rule
We'll
9
see.
9,
We'll see.
that is, my lord.
Molloy Bora was in his first case exonerated. Appeared.
But ratio that has been laid down, my lord, the rule 9 9, that cannot have a overriding effect, my lord.
Okay. On Tuesday. If you find something more, tell me on that day. So this is the contention of yours, we'll consider. Don't worry. Hello, Lordship. Yes, Mr. Parasar.
My lord, yes.
Why?
Dr. Basam has given the
You send it to your ministry on 10/1/25. What happened?
Yes, well, subsequently, the case was listed on 29/1.
Hmm.
I have sent a mail to on 1st February 22 3 officers of the department, Freedom Fighters Division, MHC, my lord. But yesterday when it was listed, I have checked, my lord, I have not given any reply. 7 days time. my lord,
Mr. K.K. Parasar, Learned Counsel, for the
that's my
petition,
comment too.
for the respond number 1 and 2, submits that he be given a 2 weeks time to complete his instructions in the manner, in the matter, full stop. In view of the above, registry to list these matters again on Dupapravision date 32. Third, third board to read. Power is Parasar. 29, huh? Mr. Parasar will forget. On 29/5/2025, on the next date of listing, Mr. Parasar shall apprise this court as to whether the petitioner is entitled to receive the pension claimed by her, and if so entitled, why why the pension has not been authorized to her. 2 things, right? Argument?